Hey everyone, Judicial Watch President Tom Fitton here with our weekly update. Thank you as always for joining us this week. I'm back after a brief vacation. A lot has gone on, including another outrageous indictment of President Trump. I'll talk about that and the latest developments there out of the corrupt Biden Justice Department and appliance judiciary. Breaking news today that a special counsel has been appointed to investigate Hunter Biden and issues related to him, and presumably Joe. I'll talk about the shady goings-on in that regard that just never stops. Your head's going to be spinning after this update, I can tell you. Plus, Judicial Watch has so much other work going on. We have a hearing next week on the January 6th videos. We filed a big lawsuit on the corruption of the archives targeting President Trump, the National Archives, 2 Supreme Court briefs about the sale of fetal body parts, just outrageous, and plus an election integrity brief that you'll want to hear about as well. I mean, first up, it looks like last week I picked was the wrong week to go on vacation. You know, it's funny, last summer I went on vacation when Trump's home was raided. This summer I go on vacation and they indict him on pretextual grounds, specifically his First Amendment activity related to disputing the the presidential election of Joe Biden and exercising his powers as a president, a candidate, and a citizen to dispute the election, not only in and around the election, but up to and including January 6th, all First Amendment protected activity. Now, this has been kind of in the offing for 2 years now. The January 6th committee had concocted a theory of criminality by President Trump. They tried to impeach him. They issued a big report, referred it to the Justice Department, and Jack Smith and other partisans at the Justice Department, and it is a partisan organization. It's controlled by political operatives of Joe Biden. Jack Smith ultimately reports, in theory, to Merrick Garland, who reports to Joe Biden. So in the end, this is a Joe Biden indictment of his current leading opponent, political opponent for the presidency next year, and obviously President Trump as former president of the United States. Just further unprecedented attacks on our Republican form of government and the rule of law. And, you know, once again, this is just further proof how the Biden administration is now officially a regime. This is regime politics. It's not American politics, as we've all experienced in our lifetimes. And this is the statement that I issued in response while we were on vacation last week to the indictment. The Biden administration has left the rule of law and the U.S. Constitution behind with its latest indictment of President Trump for daring to dispute the 2020 presidential election, as is his God-given right as a president, a citizen, and a candidate under state, federal, and constitutional law. This sham indictment is perfectly consistent with the partisan and political abuse I suffered at the hands of the Jack Smith's prosecutors for hours as they argued with me before their grand jury using Democratic talking points on the election controversies. Let's be blunt. This indictment is a naked threat and act of intimidation by the Democratic Party against any and all their political opponents. The message from the Biden regime is, we will put you in jail if you dispute elections. A free and fair 2024 election is officially impossible. And of course, Joe Biden and his political appointee Merrick Garland at the Justice Department want to distract from the conclusive evidence of Biden's personal corruption by trying to jail and turn Trump into a political prisoner. It is well past time for Congress to do everything possible under the law to undo this attempt to wreck our Republican form of government. Let's hope the courts finally step up and shut down this unprecedented prosecutorial abuse as well. And in the meantime, Judicial Watch will continue to expose and hold accountable the criminal elements in the Biden administration seeking to undo our great nation. So this is an elemental crisis as it relates to our constitutional system, whether we're a country that respects the rule of law and adheres to it, and our constitutional system, whether we allow politicians in office to jail with no good faith basis their political opponents made up crimes. Even the New York Times has called this application of the law novel. Now they're pretending, the Jack Smith team, that asking a vice president to exercise his authorities under law related to rejecting electors is criminal. So that's called petitioning your government, in the case of the president, exercising your authority as president. They are trying to, and I think one of the dirty undersides of this indictment is that they're suggesting that those patriots in the various states who were coming up with and trying to figure out how to deal with this disputed election by exercising their rights under law to create and present alternative electors to Congress in case the need arose, somehow were engaged in something that was improper, even though specifically they were doing things or engaged in activity that had been done by Democrats, including in 1960 in the Kennedy presidential campaign or the presidential election. And so this is an attack not only on Trump's rights under the law, but as I noted in the statement, kind of a broader signal to all Americans that if you dispute an election, that Democrats, in this case it's a partisan prosecution, win, they'll throw you in jail. And if you think the law allows you to petition your government on elections, you're wrong. Because if the politicians running the government decide that you don't have a good faith basis or they disagree with your reasons for asking for action on a disputed election, they'll put you in jail. And so this is a dangerous threat to our Republican form of government in the sense that it's turning the Justice Department into a political police, further turning it into a political operation and police. Obviously, the FBI is involved in this too. But also it's undermining our election. As I said, this is election rigging. It has now compromised their 2024 election. Even if it goes away tomorrow, the election's been compromised because the indictment obviously is a smear in and of itself. And right now you have not one, not two, but three indictments by Democrat operatives, and they are operatives appointed by partisan Democrats who, again, are making up or applying laws that have never been applied before to try to jail Trump. And next week, reportedly, or soon, a far-left Democrat running the prosecutions in Fulton County, Georgia, which is a Democratic enclave, according to reports, they're going to come up with some shady indictment of Trump and who knows how many others for his daring to try to figure out what was going on in Georgia and pushing officials there to uphold the rule of law. And so, it's not just here in Washington, D.C. We have this kind of broad-based effort by the party nationally, the Democratic Party nationally, to take over the levers of prosecutorial power and use that to jail their opponents. As I said, that's not the way America is supposed to work. That's the way regimes work. That's the way authoritarians work. That's the way totalitarians work. That's the way Putin works. That's the way Xi works. That's the way Castro works. And this is America. I mean, are we going to tolerate this? And I think the question is, are the courts going to tolerate this? Because the courts are being asked to engage in election interference. Now, Judge Cannon is a bit skeptical down there in Florida about what's going on, but she may clip the wings of the DOJ here and again down there because she's a little bit more sensible when it comes to the rule of law. But generally speaking, that case is likely to proceed. And she set a trial for May. Now, up here in Washington, D.C., just today you had a extraordinary session before Judge Tanya Chutkan, who is an Obama-appointed judge. And she essentially has told America that I'm running the Trump campaign. Now, I exaggerate slightly, but not too much, because she kept on warning Trump's lawyers that she would come after him if he got out of line in how he talked about the case. So you indict a man for complaining about elections and then tell him and get a judge who's friendly to you to tell him, oh, well, now you're a criminal defendant and now you can't talk about this election dispute. And if you defend yourself in a presidential campaign, even though you're a former president and leading candidate for the presidency, you're facing potential jail. So yes, a federal judge is now essentially running our presidential election by restricting, at the request of Joe Biden, whose Justice Department operatives had Trump arrested and now is trying to prosecute him. This judge is restricting the president's right to free speech during the campaign. And she basically has said, that's just the way it is. That's just the way it is. And of course, that isn't just the way it is. It's a choice by her. It's a choice by the Justice Department to restrict him. Now, she didn't agree to everything the Justice Department wanted, but President Trump now is walking a thin line every time he talks about this case and tries to defend himself from his political opponent trying to jail him, because a Biden-friendly judge, an anti-Trump judge, has threatened to jail him. You know, based on what? I don't know. I mean, because supposedly he's not supposed to talk to or about the case or to witnesses or talk about certain evidence that he may have. Well, how is that fair? This is not a criminal case that's normal. It's a political case, and the courts need to be more sensitive, but Chutkan doesn't want to be, to the president's First Amendment rights and our rights as citizens to have a full-throated presidential campaign, not one that is run by the judiciary. And what is Congress going to do about it? I don't know. I've been trying to figure out what they're going to do about it, and I haven't heard much. Have you? I've seen one member, I think one House member, and if there are others, I'm sorry if I'm not remembering who you are, but frankly, that's your problem, because if I don't know who you are, that means you're not doing enough. But Matt Gaetz has talked about bringing Garland in, has talked about defunding the Justice Department prosecution of Trump, something that I've been highlighting. Congress can also defund monies to these jurisdictions that are violating Trump's civil rights and trying to jail him up in New York and Georgia. Why are we sending any money to them? Now, does it mean all money will be cut off? No, but there are grants and expenditures that benefit, for instance, Manhattan and Fulton County that can and should be restricted if it's allowing and basically indirectly subsidizing this attack on our election system and our republic. So when Congress tells you they can't do anything, they're not telling you the truth. There's all sorts of things they can be doing. And as I said, I think I see one man talking about it, Matt Gaetz. Maybe there are a few others. I'm sure there are a few others I don't know about. But as I said, they need to be out there more on this. But of course, Congress, you know, they think let me just put it this way. Congress is on a 7-week holiday. 7 weeks. I took a vacation for a week. Probably it wasn't long enough. Do you get the 7 weeks off? Do you take 7-week vacation in a row? I can't. I guess sometimes if you have a baby or something, you get some leave, but that, you know, people who have children and newborns don't see that leave as vacation. That's parental leave. But no one takes 7-week vacations. But Congress is. And if they were serious about the crisis that we're facing as a result of this prosecution targeting Trump and other innocents, remember, they named it as unindicted co-conspirators, his lawyers, campaign operatives. Ronna McDaniel is named in there. RNC, he's not allowed to talk to her? And so what this indictment serves to do is to freeze or what I think it tries to do, is to effectively freeze Trump's ability to campaign for the presidency, and at least severely restrict it. And Judge Chutkan essentially said that this morning. Let me get the quote. I had a quote of her, what she said specifically on my Twitter account. I encourage you, always look at my Twitter account because I often have some good tweets that I forget about when I talk about things on air, but are worth sharing or worth viewing. It's at Tom Fitton. Obama judge goes off the rails. This is a good one. This is what she said this morning, Judge Chutkan, according to Kyle Cheney of Politico. He was a reporter who was sitting there. Oh, I got to take this thing off here. It's distracting me. It's probably distracting you. So I'm wearing this for my tennis elbow. It works a little bit. Keeps the pain down, I think. I don't know if it's placebo or not, but anything that works, even if it's a pretend, even if it works in my head, I'm going to use it. In addition, the more a party makes inflammatory statements about this case, which could taint the jury pool, the greater the urgency will be that we proceed to trial quickly. I will take whatever measures are necessary to safeguard the integrity of these proceedings. That, to me, is a judge out of control, off the rails. So if Trump talks about the case, she's going to punish him by threatening jail, quite specifically there, but by accelerating the case. Of course, he has rights that are separate from that, and he's going to punish him by moving the case forward into the election season. Now, already the Justice Department, by the way, Joe Biden's campaign, of which I think the Justice Department is an operating arm, has demanded from the court or requested from the court a January 2nd trial date, which is what, 3-4 weeks before the Iowa caucuses? I think the Iowa caucuses will probably be the end of January this year, right? I don't know if they've been set in stone yet. I think they want the jury to be picked in the beginning of December. So they want President Trump effectively to be in a criminal trial as the presidential primaries are proceeding. And I tell you, if a judge allows that to take place, that's an indictment of the judiciary. If they don't understand that they've been placed in an improper position by this Justice Department. This is obviously a political prosecution. They shouldn't be treating it like a normal criminal complaint, as Judge Chutkan has suggested. And this is the other unpleasant thing she said. Outrageous, really, in light of the Constitution. Well, I don't see it. Maybe my colleagues will yell at me. She said something to the effect that, you may be running for president, but you just can't talk about everything you want to talk about. Just this is the way it is. Unbelievable. And of course, much of this indictment, it was kind of coming down the pipeline. I think it was timed because also while I was away, you had additional information come up about Joe Biden's corruption. Information on top of prior evidence that further confirms that Joe Biden was running a racketeering operation out of the office of the vice president. Devin Archer, who was Hunter Biden's partner and effectively Joe Biden's business partner in these matters, testified to Congress. He's given interviews that the president or then vice president was put on the phone at least 20 times to talk to Hunter Biden's business associates. And Hunter and Devin Archer came back up with a letter written to him by Vice President Biden, thanking him for partnering with Hunter Biden in business. So, Now, of course, the left keeps on moving the goalposts, right? Oh, well, he didn't talk to any of these people. He wasn't talking business. Well, first of all, that's not technically true. When you come into a business meeting and start talking, and the reason you're there is for Hunter Biden to show these business partners that he has access to the up top echelons of government, obviously that's part of the business discussion. Your mere presence is part of the business discussion. And of course, the business that Joe Biden and Hunter Biden were in addition to Rosemont Seneca or all these fronts and money laundering operations that they were running through for Hunter and his other family members, that's just one element of the business. The other business is the racketeering operation they were running, which was Joe and Hunter and other family members taking Joe's position as a vice president, probably as a senator. I'm sure, I don't even want to know what he was doing when he was a senator, and monetizing that for personal gain. And we've had significant evidence that he, in form of this FBI memorandum that is significant because they tried to hide it from us, that the head of Burisma confirmed to an FBI source that he gave Hunter and Joe $5 million each as part of a bribery extortion plot to help essentially protect Burisma from scrutiny by government officials. So what is the response of the Justice Department? Indict Trump. Indict Trump. So I don't know what to do about the Justice Department. I guess because we need a Justice Department in theory, right? But this Justice Department's broken. It's ethically compromised. It can't be trusted to prosecute a jaywalking case, let alone a case against a former president where it's proven that they're just making up things as they go along. And I'm not just saying this as an outside observer. Recall, I was forced to testify before Jack Smith's grand jury. I was harassed by 3 prosecutors there. And I know it's political because they questioned me for 3 hours arguing with me about electors, arguing with me about First Amendment protected activity. I remember as I was questioned, I was thinking to myself, why are we engaged in a political debate here in a federal grand jury? And of course, they ignored my testimony, highlighting how I read in the New York Times, of all places, that Democrats in 2020 were wargaming scenarios that if Trump had won the Electoral College, how they could change the result by threatening secession of left-wing states from the Union. So they were planning on secession and civil war if Trump won the Electoral College. And I'm like, why isn't that being investigated? I highlighted in the elector debates to these politicized prosecutors. What about the electoral debate with John Kennedy in Hawaii, where they appointed alternative electors? And I noted that I guess it's okay for Democrats, but not Republicans to do it. And I saw this was all politics. So it's no surprise that the indictment emerged, but it's still shocking to the system because it's so politicized and so obviously corrupted and compromised. And so, Judicial Watch will continue, as I said, to investigate and prosecute our cases under FOIA to uncover what's going on. We've been doing it with Hunter. We've been doing it with Joe. We've been doing it with the abuses of Trump. And we're just not going to slow down. And I think our pressure is working in some regards because however scandalous his reasons for doing it were and what the results are going to be, they admitted that they're behind the 8 ball today because it was just announced that Attorney General Garland appointed a special counsel to investigate Hunter Biden and crime. As special counsel, though, U.S. Attorney Weiss up in Delaware, the guy responsible for the sweetheart plea deal. And this is a statement I made in response to this development. Attorney General Garland folded today, in part, stopped ignoring DOJ regulations, and finally appointed a special counsel to investigate Hunter Biden and indirectly President Joe Biden for the corrupt family business dealings. But appointing U.S. Attorney Weiss as special counsel, a man who tried to unethically slide Hunter's corrupt plea deal past a federal judge, is a sick joke. In fact, Mr. Weiss should be under investigation for his dishonest statements to Congress and his compromised sweetheart plea deal for Hunter Biden. Given the powerful and unrefuted testimony before Congress by senior IRS investigators that the criminal investigations of Hunter were obstructed by the Justice Department when Weiss was nominally running the investigation in order to protect Joe Biden. Weiss is the last person who should be special counsel. Congress should speed up and escalate its investigations of Biden corruption, as the Justice Department, as I noted, is ethically broken. In the meantime, as I keep on saying, Judicial Watch will continue its leadership role, investigating and exposing the worsening Biden corruption crisis through numerous FOIA and other federal and state legal actions. And we've been pushing on the FBI's cover-up for Joe Biden and Hunter Biden. And Weiss, as you may recall, is a U.S. attorney, right? And according to the special counsel regulations, a U.S. attorney can't be a special counsel because it has to come from outside of government. The appointment does. Now, because it's regulations, I get Garland thinks he can do whatever he wants. But it just shows you what a circus-like atmosphere, and you know, criminals aren't all that smart, right? And they kind of just do whatever they need to do to get by day to day. And that's what Garland's doing here. And the Republicans in Congress are furious because Weiss was supposed to be testifying in a week or two, and they're thinking that they won't be able to get him to testify because he's now, quote, a special counsel. And on top of everything else happening, this is all happening almost today, right? The special counsel or the Biden Justice Department, of course, they're all part of the same Borg over there. They tell the court up in Delaware, who was kind of tough on them by highlighting their skullduggerous plea deal and asking questions about it, which resulted in that plea deal with Hunter Biden collapsing, that, they said in a court filing today, well, it turns out that venue up in Delaware, that court up in Delaware, we shouldn't have filed those tax claims up there against Hunter. We're going to file them elsewhere. What is going on over in the Justice Department? Weiss should not be U.S. Attorney. Garland should not be Attorney General. And yet, late on a Friday, they are essentially cementing their hold that we know is corrupted over the Biden investigations, while concurrently asking a judge to engage in unprecedented supervision and management of the speech of a presidential candidate, Donald Trump. So what is Congress going to do? When I say they need to accelerate and increase and escalate their investigation, are they going to do impeachment? I don't know. McCarthy said that he was interested, or he said it was rising to the level of impeachment inquiry. Everyone got all excited, and so he backed away. So this is what I think you need to do. You need to call Congress and tell them to listen to Judicial Watch. 202-225-3121. And you should demand action. This is, I'm kind of half joking there. But they there are many members of Congress who know what I've been saying, and they basically shrug their shoulders and say, there's nothing we can do whenever I raise the issue. You can demand impeachment. You can demand criminal referrals. You can demand funding cuts. They can target specific employees who are involved in this misconduct and fire them effectively by defunding their positions. There are all sorts of things that can be done, and they can be done over the next few months. Because what's going to happen over the next few months is what is essentially an annual funding fight because Congress is unable to agree on specific funding bills. It's typically the government is, well, the way things are supposed to work is that the various agencies are funded in separate appropriations bills. That rarely ever happens anymore. Okay, I don't think it's happened effectively for 10, 15 years at this point. And so what happens is Congress from year to year just looks at what they spent last year or the prior year and adds a little bit of money to it, and then just votes en masse for the entire funding of the federal government. Now, I know it's a little more nuanced than that, but that's generally what's happening. It's what they call these omnibus spending bills. And so when you hear government shutdown talk happen is when conservatives typically say, we don't want to play that game. We want actual policy reform tied to our spending authority, because that's the way the Constitution is supposed to work. That's how Congress, the people's house, the people's representatives in the Senate are supposed to exercise their duties and responsibilities as designated by the people. Instead, they just kind of write a check blindly to the government every year. So this year, will Republicans and honest Democrats, and there may be one or two, because you never know come election time, take a stand against this corruption and refuse to fund it and say, we're going to shut the government down until you stop violating Donald Trump's civil rights, until you get an honest special counsel criminal investigation going, until we have impeachment done. Well, how about that? No government funding until we get impeachment done. Indeed, they could say something like, no government funding until President Biden resigns. Right? And and I say things like that to a member of Congress, or frankly to some of our friends in the movement, and they get very nervous. Because A, they know I'm right technically, but it's so dangerous politically what I'm suggesting they do, which is one of the reasons they don't want to do it. But one way around that issue of it being, quote, dangerous politically is for Americans to make their views known. Because if things go the way they're going, I'm just telling you this, President Trump's going to be in jail next year. That's the plan. He's going to be in jail next year. And the election's done. How do you have a fair election when the leading candidate has been put in jail? It's over. So if you want our republic to continue, I suggest you get on the phone, I don't know, dare I say it, engage in peaceably assemble and engage in protests. And of course, support Judicial Watch. Because our voice is essential. You know how I know our voice is essential? The Justice Department hates our guts, and they sent the FBI knocking on my door, and they harassed me and Judicial Watch with subpoenas for documents and things, and I had to go and testify for hours. So they hate us because we're effective. And they hate our voice because we say the truth and tell the truth and highlight the stakes at issue for our Republican form of government. There's no one who tells you as forthrightly, not only because based on my opinion, but based on documents we uncover, what this government is up to. It's our educational method. It's our successful education of the American people that drive them crazy. So if you think what's going on is no big deal, and we have an election rigged and compromised, and in 4 years, no one is able to dispute elections anymore for fear of jail. The censorship of Americans continue, and we've lost our liberties. And we're all supposed to. Someone was joking it's like Nazi Germany. I said, well, it's not like Nazi Germany. We're going to turn into Canada. I mean, our freedoms will slip and slide away if we don't recognize the threats to them that are occurring right now and do something about it under the law. So that's one of the things we do, and one of we kind of try to protect the republic under law, and that's through accountability and transparency. And Judicial Watch has filed a federal lawsuit, one of many that we filed on this issue, against the National Archives, which is, of course, supposed to be the entity that's supposed to preserve for the American people for time immemorial documents, right? And they harassed President Trump without basis for documents he had that were treated, that if for other presidents were treated as personal records, but they changed the rules to target Trump. And that began almost as soon as Trump left office, it turns out. And so what Judicial Watch did, we asked for documents from the archives about how they treated Trump as he left office, because the evidence is that he was treated differently than other presidents by the deep state operatives running that deep state agency, the archives. So we asked for the following documents. And this is, I think, I'm going to go through this because it's important, because the requests tell you what the issues are with the other sham indictment and prosecution of President Trump as it relates to his presidential records and his personal records. We asked for policies, procedures, regulations, or other documents outlining the archives procedures assisting a U.S. president during transition from office. Records from January 1st, 2009 to the present. So that means, how did they treat Obama versus how did they treat Trump? Coordination with the Department of Defense to assist with inventory, packing, or transport of any records from the White House on November 1st, 2020 to December 1st, 2021. So that means, because Air Force One, or I don't know what it's called after the president leaves office when he's on that government plane that takes him away. But the point is, the military usually shepherds documents around for him. Advice and assistance regarding records provided by the archives to former President Trump, his transition team, record custodians, or representatives from May 1st, 2020 to July 1st, 2021, so as he's leaving office. Archives employees assisting former President Trump or his representatives inventorying, reviewing, packing, or moving boxes at the White House from November 1st, 2020 to April 1st, 2021. Requests for assistance from former President Trump or his representatives to assist with packing, inventorying, reviewing, or storing records from November 2020 to February 1st, 2022. Archives offering or providing a secure storage location other than the National Archives for records potentially being retained by President Trump or his representatives from November 1st, 2020 to December 31st, 2021. NARA inserting placeholder pages in any of the 15 boxes obtained from President Trump's home in Mar-a-Lago from November 1st, 2020 to December 1st, 2022. So that was their analysis of the records that Trump turned over after the archives lawlessly demanded and suggested that he had to turn them over. Consultations with the Office of Director of National Intelligence concerning classification or declassification procedures of any of the alleged classified documents found in the 15 boxes recovered from the former president's home from January 21st, 21 to the present. So that was the whole scheme to look at the records in those boxes and then ex post facto designate them as classified. Because under prior precedent, Justice Department and archives policy, as Judicial Watch uncovered through its Clinton archives litigation, specifically the Clinton sock drawer case, all those records were considered personal, so-called, and not, quote, classified. So when they say they're classified, they don't really mean they're classified because there's a legal argument there. They may be more classified, but they aren't classified because President Trump took them with him and made them his personal records. That's what presidents are able to do under the Constitution and the Presidential Records Act. And you can hear from this lawsuit, we get to the heart of how the Biden archives treated or mistreated and abused Trump and harassed him over these documents. In an April 26 letter to Michael Turner, chairman of the House Permanent Select Committee on Intelligence, one of Trump's attorneys, I don't know if he's still his attorney, said the archives unfortunately has become political and declined to provide archival assistance to President Trump's transition team. So they provided him no assistance and then tried to prosecute him for boxes he had. And that's what the issue is, in part. And as I quoted, I'm going to quote myself here. This is what I said in the release. The National Archives is covering up in absolute violation of federal FOIA law the full truth about its selective, abusive targeting of President Trump. So this is why I was called before a grand jury. This is why they subpoenaed Judicial Watch. It's because we're filing lawsuits like this, because I'm saying things like I'm saying right now, calling out the Justice Department and other federal agencies' abuse and selective prosecution and harassment of President Trump. And we're not going to stop. We're going to keep on filing the lawsuits. I'm going to keep on doing these videos. My colleagues are going to keep on sending out the word about what we're doing and educating millions of Americans about this unprecedented corruption here in Washington, D.C. And of course, you know, one of the big lies that they're pushing against Trump is Jack Smith, in another active prosecutorial abuse, came out during his statement related to his January 6th election prosecution of Trump and suggested Trump was responsible for violence on January 6th. A completely political statement, had nothing to do with his indictment. He wasn't indicted for causing violence. And as I've been saying since January 6th happened, January 6th is being used as an excuse to curtail the First Amendment freedoms of every Republican and conservative and Biden opponent in the country. Okay? And we see that most directly now with the targeting of President Trump, the indictment of Trump, and the suggestion that anyone who disputes an election should go to jail or should worry about going to jail. But again, Judicial Watch doesn't slow down one iota. And one of the big issues here is that Congress has been hiding documents about what happened on January 6th. You had the former police chief, for instance, of the Capitol Hill Police just, I think he said this before, but he said it again to Tucker Carlson on Twitter, that he understood that Speaker Pelosi, acting through her appointee on the board that manages the Capitol Police, refused to, for 71 minutes, take action to protect the Capitol as it was coming under siege as a result of that disturbance on January 6th. The reason there was no security on Capitol Hill was Nancy Pelosi, and in part Mitch McConnell, because Mitch McConnell was responsible on the Senate side and participated in this. But practically speaking, Nancy Pelosi and the Speaker of the House is the mayor when it comes to the management of the Capitol Hill complex. And other issues as it relates to that are, obviously, where are all the videos? Now, Speaker McCarthy, to his credit, has allowed certain videos to come out and given access to some reporters and litigants, but they still refuse to, under law, make these videos widely available to the American people. And similarly, there are emails that no one has seen out of the Capitol Police. Who were they talking to about and what on January 6th? Why can't we see the emails? Why is Nancy Pelosi being protected? Because, of course, as I said, she should be the target of an investigation related to January 6th. So what Judicial Watch did was we sued for these January 6th videos and emails. And Congress is not covered by the Freedom of Information Act. The Freedom of Information Act only applies to the executive agencies of the executive branch, not even to the White House, just to the executive agencies. It also doesn't apply to the judiciary, and it certainly doesn't apply to Congress. But there is a common law right to public access to government records that does apply to Congress and does apply to other government officials, even if FOIA doesn't. And we sued under that law, that common law. And we sued the U.S. House of Representatives, the U.S. Capitol Police, in federal court for the January 6 videos and these emails. Now, the reports have been there are 14,000 hours of videos, and the government told us that there's 270 plus emails available, or at least initially found in response to our request. But they haven't told us what the emails are or anything like that. They think we don't have any right to them. And they're making three arguments. They're not public records. Even if they are public records, they're not important enough to be released. So all those January 6 videos, all those emails on January 6th that Congress created during this security crisis for the Capitol, they're not important for the public. They're trying to jail Trump. They want to jail, they're jailing thousands of Americans, practically speaking, right? They're well over 1,000 now in terms of prosecutions or investigations for people involved in that disturbance. And the emails about how the police were set up and what happened, that's not important to the public. Plus, they're also asserting sovereign immunity. Now, what is sovereign immunity? Well, it's as bad as it sounds in this context. They're saying that because Congress hasn't created a right to sue them, there is no right to sue them under sovereign immunity. They're the sovereign, and you just can't sue them willy-nilly unless there's a pathway. And we say, no, the common law obviates that. I think we'll probably win on that, but we'll see. So we have a hearing on this after when did we first file this lawsuit? We filed a lawsuit in February of 2021, so it's 2 years later. And the one judge just sat on it for forever, and then she got elevated to the appellate court, and now a new judge was just appointed for some additional briefing. And so we're going to be in court next week on this. So that was my long way of saying there's a court hearing next week on the January 6th videos and emails that the Judicial Watch has sued the U.S. Capitol Police for. And the thing that's disturbing to me personally, and it should be to you as a citizen, is that it's one thing for the Pelosi Congress to say they have sovereign immunity, pretend these aren't public records, pretend that there's no interest in releasing them. But it's another thing to have Speaker McCarthy effectively do that again in court. So the legal position hasn't changed with the change in leadership. So my question is, why is the House Republican leadership pursuing Nancy Pelosi's legal arguments in court against Judicial Watch by having the U.S. Capitol Police try to keep these records secret? As we noted in one of our briefs, in the courts of this country, including the federal courts, the common law bestows upon the public a right of access to public records and documents. The Supreme Court was unequivocal in stating that there is a federal common law right of access to inspect and copy public records and documents. The general rule is that all three branches of government, legislative, executive, and judicial, are subject to the common law right. The right of access is a precious common law right that predates the Constitution itself. The Court of Appeals for this circuit has recognized that openness in government has always been thought crucial to ensuring that the people remain in control of their government. Neither our elected nor our appointed representatives may abridge the free flow of information simply to protect their own activities from public scrutiny. An official policy of secrecy must be supported by some legitimate justification that serves the interests of the public office. So why is Speaker McCarthy's leadership team at the House agreeing with Nancy Pelosi that you don't have that right, dear citizen, dear patriot, to get these videos, see these emails? As I say in our statement, the U.S. Capitol Police continues to hide these key January 6 videos and emails from the American people. It is particularly frustrating that the new House Republican leadership that allowed the Capitol Police to continue to defend the secrecy, which was first pushed under the Pelosi Congress, in federal court. It's terrible. So the hearing is next Tuesday. I don't know how it's going to go. Is she going to rule from the bench? Is the court going to rule from the bench? Maybe. Or, typically I've been at enough of these hearings as what happens is I go, and I'm president of Judicial Watch. I'm not an attorney. And so my colleagues, in this case, Michael Bekesha, who's the Judicial Watch attorney on this case, senior attorney, he'll be representing Judicial Watch in the hearing, and I plan to be present there representing Judicial Watch as the client. And so I've been at many of these types of hearings where you're arguing about whether a case should proceed or not. And typically here in the District of Columbia, the courts don't like the rule from the bench. You sometimes get a signal as to where they're going. But I suspect we'll get a feel for how the judge sees this case on Tuesday. It's unlikely we'll get a final resolution as to whether we get to proceed and try to get these documents on Tuesday. But it's a significant milestone in this case, in this 2-year effort to get the January 6 videos. So this is the worst day in American history, right? And we can't see any of the videos under law here without being part of this select group that gets invited by Speaker McCarthy in to see videos. And that's not the way it should work. And what about the emails? What about the emails? So something else you should do is call your member of Congress, especially in the House, and ask why it is Judicial Watch is being fought on this public disclosure and transparency on January 6th. Why? Why can't we see all the videos? Why aren't you putting them online? Now, are there videos that can be withheld or should be withheld because there's some super secret security issues that are shown on the video? Maybe. They don't even want to go there. They don't want to show us anything in a broad way. And certainly emails, same thing. Not one email can be released. Is that what they're telling us? Everything is so secretive? It's just outrageous. So call your members of Congress, your House members, 202-225, and ask them why it is the leadership of the House is opposing transparency on January 6th. This is what I love about Judicial Watch. I mean, we don't slow down. We don't slow down. There's all this work, all this corruption's going on here in D.C. with the abuse of Trump and Hunter and Joe, but there's all this other hard work and all this heavy lifting that needs to be done for the rule of law separately, not only on those issues, but other issues as well. And we just don't stop. We're like the Energizer Bunny. I guess I'm dating myself, right? I don't even know if they use the bunny in commercials anymore. We just keep on going. So accordingly, we filed an amicus brief up in Maine. And why are we filing an amicus brief up in Maine? Because Maine was taking the position that no one effectively should be able to look at their voting rolls to make sure they're clean, which is so contrary to everything we've been fighting for and the plain reading and meaning of federal law. It's just extraordinary. As you may recall, we just had a settlement with the state of Illinois that had restrictions in their voter rolls that were initially absurd. In order to look at their, I forget the number of people on the voting rolls, it's got to be in the millions, you had to go down to Springfield, Virginia and look on, voter registration by voter registration on one computer terminal. They weren't making the data widely, available in an accessible format that someone could actually figure out how the data was being managed in terms of ensuring the rolls were being kept reasonably clean as federal law requires. And they settled and they said, okay, we'll do that now for you. Maine is still fighting, even though they had an adverse court decision. So we came in and helped one of our allied groups there with an amicus brief. We filed an amicus brief supporting the decision of the U.S. District Court for the District of Maine, which struck down Maine's policy restricting the use and distribution of the state voter registration list. The lawsuit citing the National Voter Registration Act is now in the U.S. Court of Appeals for the First Circuit, which is the circuit that covers Maine. So by way of educating you, if you don't know, so you have these federal court judges, these are the district court judges that initially hear cases, and above them are the appellate courts. And the appellate courts are divided into circuits, right? So D.C. is its own circuit. The First Circuit covers Maine and a few states up that way. The Ninth Circuit covers most of the world out in the West Coast. The Fifth Circuit covers Texas in part. So when I say the First Circuit, that's essentially the appellate that's the appellate court that has jurisdiction over Maine. And I say that not because I think you're all dumb, but because a lot of people don't know that. I mean, it took me a while to figure out how all that worked when I was working at Judicial Watch. So I certainly want to share that knowledge with you. In the last 10 years, no organization, public or private, has obtained more statewide settlement agreements or consent decrees against chief state election officials for violations of the National Voter Registration Act than Judicial Watch. As part of its list maintenance enforcement efforts, Judicial Watch also routinely requests public records of voter registration activities in various states under Section 8I of the National Voter Registration Act and is sued on its own behalf on behalf of others to enforce it. The public disclosure provision of the National Voter Registration Act embodies Congress's intent that Americans' right to vote must not be sacrificed to administrative chicanery, oversights, or inefficiencies. The Registration Act's public disclosure provisions mandates that state officials labor under a duty of accountability to the public in ensuring that voter lists include eligible voters and exclude ineligible ones in the most accurate manner possible. The law provides an avenue for citizens to check that and to ensure that only eligible registrants remain on the rolls by providing the full voter registration list open to public inspection. Without such transparency, public confidence in the essential workings of democracy will suffer. No court has adopted the Maine's argument here. Rather, all courts presented with this issue have found that the voter registration list is a record subject to disclosure under federal law. The court should reject the argument. So the last we checked up there in Maine, they're not keeping their list terribly clean. In 2020, Maine's statewide registration rate was 101% of eligible voters. Now, depending on the timing there, that's obviously off. Now, the registration rates, they're a little bit higher than they used to be. Like 90% isn't unusual. Maybe 85% is often the measure. Just think that not everyone registers to vote. That's why you have voter registration drives. If that were the case, you wouldn't need those drives. So when you have more people on the rolls who are eligible to vote, that's a pretty good darn indication that the state isn't taking reasonable steps to clean up the rolls. It means they've got more people around on the rolls who are around to vote. And so there's a good reason to check their rolls. Federal law mandates voter roll transparency. Given Maine's refusal to release its voter roll information, it's reasonable to think that cleaning up voter rolls is not a priority. Dirty voting rolls can mean dirty elections. Don't you agree? Now, Judicial Watch, as I noted earlier from my discussion of our amicus brief, is a national leader in voting integrity, election integrity, and voting rights. As part of its work, Judicial Watch has assembled a team of highly experienced voting rights attorneys, some of whom worked at the Justice Department, who stopped discriminatory elections in Hawaii and cleaned up voter rolls in California, Ohio, Indiana, and Kentucky, among other achievements. Bob Popper, who is Judicial Watch's senior attorney, leads our election law program. He previously was at the voting rights section of the Civil Rights Division of the Justice Department, where he managed voting rights investigations, litigations, consent decrees, and settlements in dozens of states. So when Judicial Watch speaks on voting issues, election integrity, our expertise is second to none. We've been doing this for decades. I remember in 2000 driving around Florida counting ballots as the left was trying to steal, it looks like, the election in Florida. And Judicial Watch's efforts to count those ballots essentially confirmed that Bush won. And that really checked efforts to steal the election otherwise, because they knew someone was watching and looking at the ballots carefully. And just in the last year or so, Judicial Watch's litigation has resulted in at least 2 million names plus being removed from voter rolls across the land. In California, as we say, Kentucky, North Carolina, Pennsylvania, even New York City. 440,000 names removed after we sued, so we settled. And one of the ways we figure out how many names need to be removed is by gaining access to these voter rolls. And I will tell you, dear voter and dear citizen, that law I referenced, Section 8I, the National Voter Registration Act, gives you the right to ask your local and state elected officials and election officials, I should say, for access to their records about how they're maintaining the rolls. You have a right under federal law to ask for these records and get access to them. So hopefully the First Circuit requires transparency in Maine, and Maine's a small state, right? It's not a big state. But, you know, it's important that every state's rolls be clean as reasonably as possible. I know it's not reasonable to expect all the rolls to be perfect. That's just not going to be the reality of life. But they got to be taking reasonable steps to clean up the rolls, and you know that's not happening evidently in Maine. And the fact they're hiding the rolls from outside eyes, prying eyes, so that they can figure out what's going on, suggests that they have something to hide. But in these days of close elections, it's more essential than ever to ensure that all voting rolls are clean, especially since the left and too many people on the right, or happy to do this, is they've been mailing ballots willy-nilly in recent years to people based on their voter registration status. And if they're not eligible to vote, you know, there's a danger that people who aren't eligible to vote are getting ballots in the mail. So that's why it's important the rolls be clean, because it means cleaner elections. And all I can say is, God bless Judicial Watch for doing this, because it would not be done. By the way, this law is supposed to be enforced by the Justice Department too, and they just don't want to do it because the left wants dirty rolls, in my view, and they oppose our doing this generally because I think they rely on dirty rolls as a little bit of insurance in case they need to go to the pot and get illegal votes in a close election. I mean, why else would you oppose cleaning up the rolls? I don't think there's any reasonable basis for doing so. So I got one more case to talk about, a big one too. So we filed amicus briefs in the U.S. Supreme Court for review of the left-wing Ninth Circuit's decisions penalizing a great public interest group for exposing the sale of fetal body parts. Now, you may recall that Judicial Watch had partnered with the Center for Medical Progress, which is run by David DeLeiden, and we exposed, working with David and his group, how U.S. taxpayer money was going to a barbaric market of body parts of unborn human beings killed by abortion. We got the credit card receipts showing how much they were paying for organs, showing that in the University of Pittsburgh, for instance, they had a fetal tissue hub, and that was promoted by saying that, well, they had a bandsaw that easily, I guess, cut up all the bodies. They were selling baby heads. They were talking about tissue generally. Some of these documents, I don't think they were in the Pittsburgh documents, I can't remember. They talked about the need to make sure the organs were fresh and never frozen. They needed to be shipped on ice, but they needed to keep fresh, but we didn't want to freeze them. So that's the abortion industry, by the way. That's what they're doing. So whenever you hear these debates about abortion, just remember the abortion ethic helps keep flowing a market for the heads and organs and body parts of unborn innocent human beings, paid for with your tax dollars. Now, Trump had turned the spigot off for that type of activity. Biden has turned it back on. And so the group that first exposed this in a dramatic way was the Center for Medical Progress, who had undercover videos of officials, I think, associated with Planned Parenthood at the time, and the company maybe they were working with, about admitting what they were doing in terms of these selling baby body parts, of one of which, you know, when in one of our cases, a federal court looked at what was going on And he opined in the decision in a FOIA case saying it looks like what's going on here is illegal because you're supposed to, the law is that you can transmit body parts of unborn human beings killed by abortion as long as you don't make a profit from it. So it's supposed to be kind of a non-profit enterprise, and that obviously wasn't the case here. They were talking about how much money each of these parts were worth, and it was really quite, it was a very for-profit approach, and the court noted that. In 2015, let me see what else is here. Oh, so what had happened was, so they had these videos, the Center for Medical Progress had these videos, and they were sued for exposing the truth. There was an injunction granted to the National Abortion Federation that prevents the Center for Medical Progress from publishing more abortion-related videos. So a direct attack on the First Amendment rights of someone who's on the wrong side of the culture of death or the right side of the culture of life. In 2015, the Center for Medical Progress released videos, as I say, that exposed employees of Planned Parenthood engaging in negotiations for the sale of fetal tissue and body parts for use in medical research. On October 21, 2022, the United States Ninth Circuit affirmed most of a 2019 lower court jury verdict that declared that a series of undercover videos produced by the Center for Medical Progress harmed Planned Parenthood and that the group was not protected by the First Amendment, requiring our clients, the Center for Medical Progress, to pay millions in damages to Planned Parenthood. Our brief highlights how the lower court's awarding of monetary damages for these accurate videos is a fundamental threat to the First Amendment. And then there was a second case. Separately, in August 22nd, in August of 2022, last year, the Ninth Circuit also affirmed the ruling of a judge in the U.S. District Court for the Northern District of California that granted National Abortion Federation a permanent injunction barring the center from releasing recordings and materials obtained at National Abortion Federation's meetings. The injunction also forbids them from talking about the videos or using them in the defense of founder and President David Daleiden in his criminal case. So they're also trying to, they've been trying to jail David, I think at least for 2-3 years now in California for exposing this barbaric, inhumane practice that it's just so shocking to the conscience. I can't, we have links to the materials. When you see what's going on, and I encourage you to do it, I think you have an obligation as a human being to see what's happening with your tax dollars. They're cutting up dead babies and selling them. By the way, the FDA admitted, by the way, that the FDA admitted in response to one of our cases that they use aborted fetal remains to test the safety of vaccines. It's part of the process. The ability, this is what we say in our brief, the ability to inform the public on matters of genuine and profound public interest is an essential aspect of free speech rights. The Ninth Circuit's erroneous decision upholding the lower court's permanent injunction amounts to unconstitutional viewpoint discrimination that must be corrected. In addition to the constitutional injuries petitioners will continue to suffer, the public continues to suffer as well by being purposely prevented from learning the facts regarding an exceptionally important issue. Abortion affects not only personal choices, but national choices like elections, federal funding, and agency regulations. It's absolutely essential that the public have the full story of what transpired on these videos. And of course, we go into how this injunction has a chilling effect. The Ninth Circuit's decision to rubber stamp viewpoint discrimination has caused substantial adverse consequences, including an especially unjust and onerous monetary award, the inability to use the videotapes as evidence in their criminal trial, and a chilling of their First Amendment rights. The right to speak is rendered meaningless without an audience free to listen. And of course, these records and videos are a matter of public interest. The videotapes that were released changed the national and state landscape in dramatic ways. The general public was largely unaware of the shocking underbelly of the abortion lobby, which petitioners exposed through the release of the videotapes. Petitioners' videos changed federal and state laws, spurred federal and state investigations, changed private business activities, and had led to severe public backlash. By suppressing the further release of information, the Ninth Circuit effectively blocked access to information the public had a right to know. Absent this court's intervention, the petitioners and the public are left with no avenue for legal relief for the adverse consequences that have suffered and will continue to suffer. So what we're asking here, and what our friends at the Center for Medical Progress are asking, is that the Supreme Court take up this case. I think this is a cert request, if I recall correctly. The Center for Medical Progress exposed the horrors of the sales of fetal body parts, and the courts effectively joined the abortion industry in trying to destroy the center for telling the truth about this nightmarish conduct. The Supreme Court should step in and protect the First Amendment right of citizens to expose and criticize the dark secrets of the abortion industrial complex. So I know there are a lot of debates going on. We have this nightmare at the border. We have this nightmare of corruption here in Washington, D.C., but we have also this other nightmare, and which is the killing of unborn human beings, which I think is morally and legally and constitutionally and ethically objectionable. But on top of that, cutting those babies up and selling their body parts to researchers to use to create, test vaccines, right? We found that fetal parts were used to engage in gain-of-function research. So gain-of-function research was dependent on access to this nightmarish, barbaric practice of harvesting fetal baby parts, often with taxpayer dollars. So if you want that stopped, and if you want to protect those who are willing to blow the whistle on it, then I think you want the Supreme Court to take this case up. And so Judicial Watch was proud to submit these amicus briefs on our behalf and on your behalf, those of you who support Judicial Watch, and those of you who don't support us directly but morally support us. So that was quite the update, wasn't it? And as you can see, Judicial Watch is in the center of all these major debates around which our country may rise or fall. And as I say, our republic is tottering, and I'd like to think that Judicial Watch is standing there, at the firmament, right? At the wall, trying to hold the republic up through our litigation and through our educational efforts, like I'm sharing with you today. And if you support our work, I encourage you to go to our website and make a donation at judicialwatch.org and join the hundreds of thousands, if not millions of Americans who have supported Judicial Watch over the year. We're not just a group, we're a cause, we're a movement. I encourage you to support our work. God bless you, God bless America, and I will see you here next week on the Judicial Watch Weekly Update. Thanks for watching. Don't forget to hit that subscribe button and like our video down below.